Ready, Kevin?
Well,
All right. You said 4 minutes, didn't you? 4 minutes.
we just want to make sure we're able to hold this up. Got it? Now,
You may.
ladies and gentlemen, like Mr. Creekmore said when we started this case, anticipating that the state would put on evidence and then try to convince you that these number of options that the state has proven, you would choose one of them. At the conclusion of his argument, he indicated the only evidence that you should consider, only verdicts that you should consider, that's capital murder. And I'm going to talk to you a little bit about the 4 options that they claim are in the instructions, but they're really 5 options. 4 options are capital murder, murder, first degree, second degree murder, manslaughter, and the 5th option, quite naturally, is not guilty. I want to talk to you a little bit about kind of where things started in this trial and go through a lot of different things. I'm going to try to make it through all the information that I have in 45 minutes, and that's not a whole lot of time to go over everything that I want to go over, because there's a lot of questions that I have in all these notes that I'm going to lay out for you that I think there's problems in the state's case. Now, if I say anything or I represent anything that's not factual and you disagree with me, please say to yourself, hey, Mr. Horan, you were not paying attention to that testimony, or you misheard something. You remember what you remember that came from that witness stand and you saw on that screen. Not what I tell you, not what they tell you. Just like when Mr. Creekmore told you that my client made the statement he was a big man on campus, that just wasn't said in this court. He did not make that statement. That's just an example of what I'm talking about. You remember what you heard, what you saw. And also, what you can do is consider your verdict or lack thereof based on a lack of evidence. That includes whether or not certain things that you felt like you should have heard, but you didn't. We're going to talk about those things right now. We'll start. First of all, and I've got so many questions on this pad, and ripped off 2 or 3 pads. I'm not as computer savvy as Mr. Creekmore, but I want to talk to you a little bit about some of the things that we have problems with. Why in the world would an agency who spent $30,000 not on technology as far as the computer stuff, all that's taken care of. Mr. Baker's training to do those things. They spent $30,000 and running, according to the chief, on collecting evidence of Jimmie Herrington's apartment, J.Lee's car, and also from Tim Herrington's car. $30,000. Not only did they collect this evidence and did something they've never done before. Never done before. Sent it to a lab out in California for the sole purpose of making sure they can extract every possible bit of evidence from Jimmie Herrington's apartment. Jimmie Herrington's car, J.Lee's car, but obviously not, for whatever reason, J.Lee's car. And it's not that big a deal, Your Honor, ladies and gentlemen, that they didn't go to J.Lee's apartment initially. They needed to go over and get his toothbrush so they could compare his deal. But later on in the investigation, as the days traveled on, it seems to me that they would have gone over and said, hey, look, let's go in here and try to figure out whether or not somebody had been here after they interviewed all these people and said Jay Lee was having strangers and hookups coming into his apartment. Now look, folks, I'm not telling you they would have found anything over there. Not what I'm saying. What I'm saying is, on January the 21st, Timmy Herrington became a suspect. That stopped all the other investigations. On July the 10th, 2022, they should have treated all of our apartments like a crime scene. They didn't do that. No indication whatsoever moving forward to September the 5th, 2024, when they got this lab report, that they should have gone back to Molly Bar for the purpose of drawing DNA evidence. No, that's not what I said. What I said was that they should have reinvestigated their case after September the 5th, 2024, when this laboratory told them there's no evidence. Should have at least gone back to Molly Bar like they did when they went down to Grenada and went over to Lafayette Place. That's the whole purpose of that piece of examination. Now, ladies and gentlemen, I want to go down a few things real quickly before we move into some slides. You know, he indicated on his opening statement that my client was deceptive. Let's talk about deception in this case. Jose Reyes, he indicated, hey, look, I can't tell you anything about his personal life. Don't talk to Janelle. Again, what I'm trying to establish here, I want you to understand here, that during the course of this investigation, they should have broadened their scope a little bit more and say, let's look at these things going on in Jimmie Lee's life. Let's look at some of the other people outside of this direct circle. Let's look and see what's going on. What about Tylen Mathis? You know, he's the individual that not only gave deceptive information, he's the individual they eliminated by virtue of the fact that his ping location was at his house. Said he was looking at porn. In testimony here, the phone didn't put the person there. Again, I told y'all, and I told the officer, I'm not saying Tylen Mathis committed any offense whatsoever. All I'm saying is that he information. Why in the world does Tylen Mathis get the benefit and not Timmy Herrington get the benefit? Ping location, providing deceptive information. Why is the standard being applied differently to Timmy Herrington in that circumstance? Khalid Pierce had to show him an exhibit on the stand he was shown on the stand the conversation that he had with Mr. Jay Lee about what? Choking conversation that they had between each other. That conversation pretty succinct, pretty detailed about what you like, what you don't like. That happened in June, shortly before Jay Lee had this encounter with my client. Khalid Fears was an associate, apparently, of Jay Lee, and must have been pretty good friends because they were talking at 5:58 in the morning, 3 or 4 minutes. And if you remember the conversation that we fought over in the courtroom, y'all heard us arguing about it, about what happened that particular morning, the conversation, peers indicated from the stand that they had a conversation, and the gist of that conversation was what? Y'all remember? Jay Lee told him he was going back over to a place that he had been before, hooked up before, and they were going to have some fun. Now, I'll tell you that what's important about that conversation is, if you look at it, and the conversation is on the screen pertaining to Mr. Peters, he testified that he remembered this conversation. Not only did he remember the conversation, he identified the conversation in the exhibit. This is exactly what he said. I like to go tap to tap. Period. Okay, I'm not crazy. I feel like we are into BDSM, lead during sex. I enjoy a little mutual aggression. Correct. Oh, you like to choke and be choked. Now, that's not Peter. That's Jay Lee. What he testified from the stand, not only did he identify the message, he stated that he remembered that conversation specifically. Heavy on that. You have any kinks? I don't think so. I like to be aggressive and also put in my place. Now, ladies and gentlemen, I asked Brian Baker, Detective Baker, whether or not he had investigated or looked into the Snapchat history or the Instagram history of Mr. Lee and even my client to determine whether or not there was any similar type conversations between them in the history of Mr. Herrington and Jay Lee consistent with this conversation. And I don't remember exactly what he said, but I think what he said, I didn't look. But wouldn't that be important to this investigation if they're going to claim that my client lured him over there for that to have occurred? But look back at the pictures, pointing to Mr. Herrington, they've known each other 2 or 3 months. Wouldn't you look at their history to see whether or not Jay Lee, Jimmie Herrington, had any type of conversation like that? Well, subpoena didn't go back that far, according to what we have in the cell record. All right. I want to talk to you a little about the first conversation, the first time that night, Jay Lee and Jimmie Herrington, there was any potential communication between the two. The first time was from not Jimmie Herrington. It was from Jay Lee. It said, "You and Austin," on the screen. "You and Austin." That came from Jay Lee to Jimmie Herrington. Conclusion of that text, that snap, what happened then? Jimmie Herrington didn't respond to that message. Jay Lee is the individual at the time of that text. It says at 2:24:44, Jimmie Herrington did not respond. Now I'm going to tell you, ladies and gentlemen, first thing I want to say is straight up front. We introduced the lock audit report, and the state was slamming and going crazy about it. That's not reliable. Well, this is what they gathered in their investigation. And I thought it was quite odd every time that there's a piece of evidence that supported the defendant, it's not reliable. The lock audit, the burglary report, y'all have both of those reports. You remember what Detective Baker said about the burglary? Let's get to the burglary real quick. I mean the lock audit. Go back to the lock audit, then I go to burglary. You remember what he said on the stand when he identified the document? We got an email telling us that lock audit we understand, happened through the lockout. And it appears to be, according to the evidence that they got on the search warrant, they got a search warrant on July the 22nd, the same day they went in Mr. Herrington's apartment. They got it for the lockout, for the resident key of his apartment. Search warrant returned for Jimmie Herrington's lockout. The door opens July the 8th, 2022, 6:41. Door opens July the 8th, 2022, July 8th, 6:45. Ladies and gentlemen, y'all take that lockout, you put whatever weight and credibility that you want on it. But they didn't spend $30,000 or $3 trying to determine whether or not that was accurate. He just said it was unreliable. We said from the stand, said he had an email from somebody that said it wasn't reliable. It was never introduced in the evidence, folks. Never was. Now, getting back to conversations that morning, I asked the chief what conversations were in there that showed that the whole theme of this case had been proven that my client was getting out. Now here's two guys, young guys, talking to each other. Nobody's looking into their world at all. You would think that you would have all kind of conversations where 3 days ago or the last time they hooked up, there would have been some beginning of some problem with their relationship. So you go to the next message, the Instagram message, where J. Lee, this word say, according to the chief, one word in the Instagram message, number 4. I just wanted to be able to say, I had you, be did. Now, Detective Baker, as you recall, when I specifically asked him, I said, Detective Baker, you can't tell us what the context of these conversations are. And I made reference to the conversation in the bottom of the Snapchat pertaining to something about, like to try to hurt me or something like that. He said, we have no idea what their prior conversation was about. That's exactly the point, ladies and gentlemen. We have no idea what these two young men talked about when they had a 14-second Snapchat conversation before we came over. We don't have any idea. But right here, Chief of Police, Oxford, Mississippi, when asked, what information do you have that supports the idea that he was about to out him? I just wanted to be able to say, I had you BDL. Again, fun to have been the first guy, experiment over. What does that tell you? What it tells me, and the reasonable interpretation is, that Jay Lee's making a comment to Jimmie Herrington, hey, you had an experiment over. I don't know exactly what they're talking about, but it didn't sound to me like Jay Lee is making any type of threat to Jimmie Herrington that he's going to out him. That's what the state wants you to believe. That this man killed Jay Lee over this one word. He said, say. That's what he testified to under oath. You go down to the remainder of it. He said, also, I nutted on your floor, so you should get that up, by the way. Oh, and the nude was fake too. Back to block now. He's blocking Mr. Herrington, according to this, again. Put anything in evidence that he had even blocked him that particular night. He said, back to block. Hang up on him. I conversation is over. Now we go to the next Snapchat, and I'm going through these because I think it's very important. I've talked about the 14-second call. But I go down to the next one, where the Snapchat red eye. Who the TF is this? Now think about that red eye account. Ryan Baker admitted he had testified under oath previously that my client created that account for this transaction. We testified to, I showed it to him. His prior testimony, and he admitted, created that. I testified to that. Fundamentally false. I don't know if he had bad information or he misread it. I don't know. But that's a critical part of their case, whether or not this young man created this account for the sole purpose of luring him over. Not saying he didn't reopen it. That's not the point. They admitted on the stand, they do that all the time. Who the TF is, that's a response from Jay Lee to an invite from Jimmie Herrington. He's accepting that. Is what he's doing. The next Snapchat involves basically, he says, what did you delete? These are conversations you can read them in context. What you can understand is Jay Lee is the one controlling this conversation. It's clear from that. Jay Lee is controlling the conversation the entire time through this Snapchat history. He says, what did you just delete? You made it like this. And when you get over here, you wouldn't even eat my ass 1 hour ago after I cleaned and everything. Then you proceed to nut in my mouth. Think about that. I hate to talk about this stuff, but this is what the facts are. Think about what happened later on in the fears statement when he says that he's going over there to do something we've never done before. It can't be that Mr. Herrington is going to give him more upset. It can't be. This conversation right here contradicts that. Then he goes into all this information about effing nobody raw. Then he says, I'm going to stop harassing you now, and that you want to stop blinking. You know how much of an asshole move that is. What he's saying is apparently he's upset because Mr. Herrington is telling him, maybe we're not going to look up anymore. Right. Now, the Snapchat conversation next is the 14-second call that we talked about a few minutes ago. 14 seconds. They had a phone call and asked Mr. Baker about it. Nobody knows what that conversation was about. Nobody has any idea whether that conversation referenced any prior conversation or something they talked about when they got together earlier that night. Who knows? And I talked to y'all when I did open statements talking about speculation and wonderment, drawing conclusions, making the quantum leaps. That's what the state wants you to do. That all this conversation, they won't connect the dots with speculation, no facts to support, because we just don't know what they were talking about. Now, if you look at the next Snapchat we're going to talk about, it's number 8 in my list, questionable stuff before. Try not to say cussing in here. Like you done did some questionable SHIT before. But that was too much. Do we have any idea what they're talking about? Absolutely not. There's nothing else in that in the text string tells you whether or not they were talking about our sexual activity, doing anything moving forward, or anything that they'd done 3 months ago, It's not in there. We don't know. Remember Ryan Baker's testimony. We had no idea what they're talking about. And here we go. I'll come if I get head in front of him. Jay Lee is controlling the entire conversation between these two men. It's obvious and apparent from this conversation. You move on down to the conversation that they continue to have that night. All this is in evidence. You'll be able to look at it. But if you move on down and you look at some of the conversations that they had, it continues the same way. Have a good night, Tim. Only way I'm going to see you if I get head up front. And you keep going down, and Tim says, okay, why do you keep leaving? And that's just okay. Tim says, I'm sorry, I misspelled something, and okay, I'll do it. That's Jay Lee telling Timmy, what do you believe? He's the one that's being the dominant actor in this particular conversation, not my client. You know, if you do that, it won't end up good for you. Where in that conversation that they just had warranted some kind of comment like that from Jay Lee? Does that mean he's scared? No, he's the one saying, I may or may not come over there. If you look at the remaining of the text, he's the one that makes his comment. What prior to that warranted that? My client says, what do you mean something fast? Like hurt me or some shit. Where's the threat there from Mr. Herrington? Where is the alluring aspect of this conversation? Timmy says, I know. And J.D. says, possibly tonight. But then he goes on to say, puts conditions on it. He continues to say, basically, I'll come later on tonight. And Timmy says, I told you I'm leaving later today. And we know that's true. Because if you go back to the prior text message about the screws, we do know Mr. Herrington, all this is in evidence, talk about his trucking company, he's talking to Tyson, he's talking to Mr. Love, Darius Love. He says on here, says to Tyson, I'm going to need those screws tomorrow. They go through this. I left them at Love's house. You're going to have to go get them. I'm in Hattiesburg. Then he talked about the tool bag. I'm going to leave around 9:30. He's telling Mr. Lee, you coming over? I got to go somewhere tomorrow. If you come, I'm letting you know. When Mr. Lee says, I'm probably coming, I am not going to be here throughout the day. If you're coming, come on. Now, I kind of skated over this, but y'all remember that Mr. Lee, the first time, 4 o'clock, goes to Mr. Herrington's apartment completely unannounced. Ryan Baker admitted to that. Completely unannounced. Second time he comes over, after 14-second conversation, the last thing that happens at 6:03 is a Snapchat of open. No doubt about it. That does not mean that's when Jay Reed went in the apartment. He says open. At 5:54, he says, I'm coming. And he says, what's that mean? Apparently, ladies and gentlemen, Mr. Lee consensually went over to Mr. Herrington's apartment. And we're going to talk just a little bit about how long does it take to strangle. Nobody ever testified that the context of that search was, how long does it take to strangle someone? Now, if you recall, again, Mr. Baker, Detective Baker, testified August the 9th, 2022, that was the search. And he admitted when he testified to that, that was not factual. The text was, the search was, how long does it take to strangle? Do we know what context that was? Absolutely not. Do we know whether or not that was based on something that Mr. Lee had said to Mr. Herrington, consistent with the conversation that he had with Mr. Fears about what he'd like to do? Absolutely not. There's a possibility there, ladies and gentlemen, and more likely, probably. Because how do we know that Mr. Herrington wasn't taking that very seriously? Because 7 seconds later, point in time, that got to type it in for Detective Baker. He was looking at something else. He was on Instagram. He would no more paying attention to that man in the moon. Agree with Detective Baker? Ladies and gentlemen, I'm going to go through some of the questions that we have about this case. Why in the world would these exhibits we talked about not sent to the lab? Why wasn't George Shiro here?
Objection, Your Honor.
Any objection, go ahead.
You're not going to hear, you didn't hear from Mr. Shiro, but you heard from some of the stuff in his report.
Why objection to Mr. Shiro about not
Mr.
hearing?
Shiro,
I'm always going to cross.
Mr. Shiro's report said they did not request fingerprints. Request condoms, didn't request keys, latex gloves to be tested. None of those things were tested. Y'all heard that. I want to go through some more of the things that we have some concerns about. Think about this right here, folks. After the lab report came in, and they got it, and no doubt they at least had a preliminary report before, they go down to Grenada and start searching 2 locations. Lincoln Road, where they've been before, and they go down south of the Herrington home. We don't have any idea if they took drones down there, people down there, what they took down there to do those searches. We don't have a report. When they did the initial search, the Molly Bar, do we know whether or not they searched it with men, drones? Who went out there and searched Molly Bar trailers? Nobody. We don't know. We don't know how many people went out there and what they did, because we just don't have a report of those things. Ladies and gentlemen, answer this question right here, if you can. Why in the world, Detective Baker, Mr. Porter, would not provide a report on something they did 4 weeks ago? Why would they do that? Why would they not provide that report? The Berlin report is in evidence. I want to talk a little bit about that. The Berlin report provided Mr. Lee's car, the door open and closed. Another fight in this courtroom about that particular item. The search warrant returned for the Ford Fusion burglar report. At 7:34 a.m., driver door open, closed. 7:34:48 p.m., the passenger door open. That's the burglar report that was introduced into evidence. You will have it. I encourage you to look at that page in that burglar report. 7:34 is what time, ladies and gentlemen. That's the time they claim Mr. Lee's car, 7:25, went in, 7:34. My client, close proximity at that time, sitting on camera, running away. 9 minutes from the time the car went in, the time that my client, it can't be both, ladies and gentlemen. It can't be both. He can't be running away, and also he can't be opening and closing that door. Can't be. Now the verbal report, again, testimony from an officer that said, hey, look, you can't depend on that report. It's unreliable. Now, he didn't tell us why it was unreliable, how it was unreliable, or what mechanism they proved that it was unreliable. All they said, it was unreliable. I want to talk to you a little bit about what happened in Jimmie Herrington's part and the times and things that they claim happened in the part. 6:03. They claim Mr. Lee at least said open the door. Later, maybe a minute later, maybe 3 minutes later, showed up Mr. Harrison's park. Went inside. Something happened. Think about the fact that he's in Walmart at 6:41. He's in Walmart. Checks out 6:49. If they'd gone in there and talked to the attendant to say, you know, he was looking at this garbage can, what did he say to you? They didn't do that. And why would Mr. Herrington be getting a garbage can in his car? Why would he be doing that? And think about this question that I've had ever since we started this case, and they give me the discovery in this case. It's like our report. How is it that Mr. Lee is at Mr. Harrington's apartment at a time when the lockout report says activities going on at that location? Ladies and gentlemen, I want you to look at that. I've got two questions that I want you to consider. Maybe the biggest two questions in this case. The first one is, how does the state establish beyond a reasonable doubt that Jay Lee was not alive with Jimmie Herrington when the car arrived at Molly Bar Church? No one's testified that they identified Mr. Herrington driving the car or Mr. Lee. Think about the fact that fingerprints that were found in his car were Jay Lee's fingerprints. Think about the fact that Mr. Harrington's prints were not found on the driver's side of the car or anywhere in the car. How do you know?
That's not evidence.
Testified to, Your Honor, by the officer.
Like with J.D.'s prints, nobody testified to that.
I'm going to let him make his argument. You'll have the opportunity, but
The second question that we have, and probably the more important question, is how does the state establish beyond a reasonable doubt that Jay Lee was not alive when Jimmie Herrington left for Walmart and returned? Jimmie Herrington got back to his apartment at what time? 7:02, something like that. He left Walmart, 7:09. He left Walmart 6:49. Why would he need a boxcar? He's headed. Why would he need the garbage can? Didn't have a boxcar, box truck that was at the links. He drove back. There's no evidence whatsoever that Jay Lee was not alive at that time. Think about why that's important, folks. It's because haven't proven anything in the apartment, the fire, hair, DNA, saliva, anything like that. If he was not alive in that apartment, he got back in Walmart. Now, think about this prospect. We talked about possibilities because the state laid out possibilities. Let's assume, giving the state the benefit of all their evidence, that when he left Walmart, Jamie was alive. Let's assume he left Walmart and Jamie was alive. Let's assume that Jamie was still in his apartment. Because if you look at the ping information that we had to introduce into evidence, not the state, we had to introduce into evidence the ping locations 715.
You have 4 minutes.
Thank you. 715 on. These are the ping 721. These are ping locations that basically tracks the area to Molly Bar Trails from Mr. Herrington's apartment. How can they establish Jay Lee wasn't in that car? How can they establish that he was not alive at Jimmie Herrington's apartment during that time? Mr. Herrington possibly, we're talking about possibilities here. If you believe that Mr. Herrington found his way to Grenada, if you believe the theory that they got that he found his way to Grenada with a body, you believe it. If you find that, how can they state or prove that when Mr. Herrington went to Walmart, Mr. Lee wasn't still in the apartment alive? I'm asking them. Tell you that. How he went back to Walmart, 749, when he got the boxcar, which we know he had a reason to get the boxcar because the screws were there. How can they say he didn't walk up the steps, open the door, and Mr. Lee was there alive? Maybe, because we got the ping location stuff, leaving the apartment. What if Mr. Lee was there? Dead. Nothing in evidence that support that. Here. He could possibly been alive. Mr. Herrington came back. Because we do know this. He wasn't going to load up that car in the back of that car in the parking lot of Walmart. It made more sense if he got the box car and brought it back to Walmart. Box truck, brought it back to Walmart first. The court hasn't instructed you that if Mr. Herrington walked in that apartment, found Jay Lee, look at the lock, resident lock door. When the door's open, the door's closed, and then again, look at it. You cannot eliminate the possibility. Jay Lee was alive, he left to go to Walmart. He came back, he wasn't. That's a possibility. They got to eliminate all the possibilities. Not us. They did. They have to eliminate the possibility that Jay Lee got in his car with Jimmie Lee. They got to eliminate the possibility that didn't occur. They can't do that. Jimmie Herrington, we're not ever denying the fact that he was running away from the car. We never made that a point of contention. They made it a point of contention. Having photographic evidence that both of those men were not in that car at that time. It's a possibility. I'm not saying we have to prove that. I'm saying that's a possibility. Ladies and gentlemen, you've got to look at the burden of proof in this case. The burden of proof is beyond a reasonable doubt on all four of them.
Your time's up, Mr. Owen. Wind it up, the time's up.
You got to look at four options. The only option that's possible in this case, if you take the state's case, everything they have, most favorable to them. Most favorable to them is manslaughter. That's the best option with them, ladies and gentlemen. The most reasonable verdict, and the one that's supported by the lack of evidence, is not guilty. Thank you.
We got about another 20 minutes. Y'all good? Y'all gonna need any time to set up, or y'all good to go?
Yes,
All right. Anyone wishing to leave now, you can. We're going to have about 20 minutes of testimony once we get started.